Gary DeWaal here, and this is Bridging the Week for April 13th to 17th, and today is April 20th, 2015. Good morning. No single theme dominated news regarding financial service firms and regulation last week. Although many enforcement proceedings were ended worldwide by settlement, including 18 actions brought by CME Group, a federal judge in Illinois refused to dismiss a spoofing indictment based on facts that previously had been the subject of civil enforcement proceedings brought by the Commodity Futures Trading Commission, Financial Conduct Authority, and the CME Group. Separately, the U.S. Department of Labor issued new proposals to extend fiduciary standards to advisors of purchasers of 401k and IRA investments. We have a lot to cover this week, so let's get started. Commodity Futures Trading Commissioner Sharon Bowen argued for granting authority to the CFTC to impose user fees on certain industry participants during a CFTC reauthorization hearing held last week before the United States House Committee on Agriculture, Subcommittee on Commodity Exchanges, Energy, and Credit. Although Ms. Bowen was not specific on the type of user fees she would recommend, she said, quote, "There are many ways to structure such a fee, including establishing de minimis fees on all trades, fees on certain riskier trades, or annual fees on registrants," end of quote. Ms. Bowen claimed that the Commission required additional resources to, quote, "keep pace with our duties," end of quote. She said the CFTC current underfunding, quote, "has been an obstacle to the industry, including end users," end of quote. During his appearance before the same subcommittee, CFTC Commissioner J. Christopher Giancarlo suggested that before the Commission seeks additional resources, it should reduce quote-unquote inefficiencies in the Commission's oversight. Mr. Giancarlo claimed that it's the CFTC's own regulatory agenda that contributes to its workload. In his testimony, CFTC Commissioner Mark Wetjen identified a number of issues the CFTC should rapidly address. These include ensuring that differences are resolved with European regulators to ensure that U.S. clearinghouses' regulatory framework is assessed as equivalent to European framework. Otherwise, European banks will be assessed a higher capital charge for clearing trades through U.S. clearinghouses. Clarifying the CFTC's requirement that block trades involving swap execution facilities must occur away from the CEF. This has caused difficulty for CEFs and Futures Commission merchants in complying with their pre-execution credit checking obligations, and enhancing transparency regarding clearinghouses with respect to stress tests evaluating how much of a clearinghouse's own capital should be used and under what circumstances in case of a major clearing member default. The CFTC sued 4 defendants, including a Canadian law firm and a lawyer, in a federal court in Illinois for engaging in illegal fictitious transactions involving single stock futures. The purposes of this trading, said the CFTC, was for the respondents to transfer funds from the law firm to another corporation. The 4 defendants are Metro West Law Corporation, a Canadian law firm located in Vancouver, Canada; John Briner, an attorney also residing in Vancouver, who is the 100% owner of Metro West; Tech Power Inc., an information technology company located in California; and Matthew Marcus, the President, Secretary, Treasurer, and Director of Tech Power, and a client of John Briner. According to the CFTC's complaint, on 7 occasions, from January 28th to February 5th, let me say 7 consecutive days, Mr. Marcus and Mr. Briner entered into 624 round-turn trades for 1,248, quote, "perfectly matched, prearranged, non-competitive transactions in single-stock futures," end of quote, traded on One Chicago. The objective, alleged the CFTC, was to move U.S. $390,000 from the Metro West account to an account in the name of Tech Power. Previously, Metro West had been placed in custodianship. A federal court in Illinois rejected Michael Casilla's efforts to have dismissed the federal indictment against him for alleged spoofing that was filed against him in September 2014. Mr. Casilla, the prior manager and sole owner of Panther Energy Trading, was indicted in Chicago for alleged spoofing activities involving futures traded on CME Group and ICE Futures Europe from August through October 2011. Mr. Casilla had sought to have his indictment dismissed on the grounds that the prohibition against spoofing under federal law is void for vagueness, as is the commodity fraud provisions under which he also was charged. In rejecting Mr. Casilla's arguments regarding spoofing, the court reasoned that because First Amendment rights were not in controversy, meaning regarding restrictions on freedom of speech or religion, quote, the court must assess whether the statute is unconstitutional as applied to Casilla's conduct, not to the conduct of the hypothetical legitimate traders who voiced concerns about the statute's applicability to practices such as partial fill and stop-loss orders. The Commodity Futures Trading Commission, the UK Financial Conduct Authority, and the CME Group previously brought enforcement proceedings in July 2013 and entered into simultaneous settlements with Mr. Casilla and Panther Trading related to the same conduct underlying the indictment, assessing aggregate sanctions in excess of approximately $3 million and various trading prohibitions. The United States Department of Labor issued a proposed rule that would expand the number of persons that would be considered a fiduciary for providing investment advice or recommendations in connection with retirement assets. Specifically, as proposed, any person who provides such advice or recommendations to an employee benefit plan, plan fiduciary, plan participant, individual retirement account, or IRA owner for a fee or other compensation would be considered a fiduciary, be subject to trust standards of care and loyalty, and could be held liable for breach of such standards. Simultaneously, the Department of Labor proposed a new exemption to its so-called quote-unquote prohibited transaction rules that would permit firms and employees to continue to receive commissions and revenues sharing in connection with advice to retirement investors, defined as participants and beneficiaries of participant-directed employee benefit plans, IRA owners, and the sponsors of non-participant directed plans with fewer than 100 participants. And finally, the CME Group issued notices regarding 18 disciplinary actions last Friday, all involving modest fines from $7,500 to $35,000, most involving allegations of improper exchange of futures for related positions and block trades, wash trades, and position limit violations. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week and ciao.